Thank you, Lordship. 19801.
801.
801.
Lordship, I am the petitioner disabled person. Since 1 year waiting.
Second April, not to be deleted.
Tentative not to be deleted. Grateful, Lordship.
Item 1.
Lordship, though there is a delay of 252 days, but this is a fit case for Lordship's consideration. The first aspect is this is a case wherein the SSC themselves had said that they earned a dividend income of 2 crores 53 lakhs on the investment made on the same day. That is nearly about 40% of the amount which they had invested.
But you said two things. First, you said, what did you say first?
Fictitious.
There is a fictitious losses which I had said culminating from the return which they had said that they had incurred losses.
Yes.
This is only a case of clarification. It's not a case of change of opinion. Lordship may kindly see. I will just show this to your Lordship.
First, you said it's a sham transaction.
This is a no. I first say this is a fictitious loss. I say that this is a sham transaction because they have tried to hide this aspect that they earned the dividend income only upon notice being served upon them. Did they reply and give me all of this reasoning? To which thereafter I said that this is a case of a sham transaction.
Show that.
Yes, your Lordship. Lordship, firstly, notice was served upon the AMC, which is the JM Financial, after I had taken the due approval from the competent authority. The JM Financial thereafter sent me a response saying that there are certain aspects which they have hidden, which are pertaining to the transactions which they had conducted with them on the same day where they had earned the dividend income of 2 crores 53 lakhs. Thereafter, I give them a notice for response. They give a response to me. This is at page 35. This is a part of the order which is of.
Yeah.
This is at page 35, your Lordship. The last paragraph. It is replied by the SSC on 28th of March 2022 that the investment of 3 crores 50 lakhs made on 23rd of March 2018 in JM Equity Hybrid Fund and the same day earned a dividend income of 1 crore 41 lakhs. How can this be possible? This is unbelievable. And further invested rupees 2 crores 80 lakhs on 28th of March and earned a dividend income of 1 crore 11 lakhs. On the same day, the SSC has submitted copy of the bank statement and the account statement of the JM Financial Mutual Fund and requested to drop the proceedings. So they have conceded to this. Thereafter, we issue them a notice under 148, which they challenged. And only aspect which they have said in all of the...
It's not two different things.
These are not two different things. What I'm trying to say... What I'm trying to say over here is that the reasoning which is provided under 148A(b), clause B, and 148A notice which was provided to them, they are the same thing. They are not culminating out of two different facts. It is arising out of the same transaction. So this cannot be treated differently. Now, Lordship may kindly also note that the judgments which the Honorable High Court had relied upon pertain to the earlier regime. This is not as per the regime of 2021 of the Financial Act, which talks about that only once you take in information, you have a preliminary information against them, then you take their response and then you frame your opinion. This is something which the Honorable High Court has not looked into. What they are trying to say is you have to provide it in the notice itself that what wrong they have done. That is not the case. Now, as per the present regime, here we have to only see that the information which they have provided.
Show the provision.
Yes, your Lordship.
188.
148A.
148A.
Yes, your Lordship.
B.
Lordship, I will go through a whole of it because all of them have to be read together. 148 talks about conducting inquiry, producing opportunity before issues of notice under 148. The assessing officer.
Let's lay the book out. Have you annexed the provision here?
Lordship, we have not annexed the provision. Sadly, this is... And I will show your lordship what the present position is and how is it different from the earlier regime.
No, we did check up in the office. The footnote is this present position. 1 second.
148A.
Yes, capital A.
Yes, your lordship.
Not have the,
Let,
this has changed from 1st of September.
yes, let me finish. Let me
Yes, we
finish.
got it here.
Footnote. 1st of September 20.
There.
It came into effect only after 1st of April 2021.
D, I think. D.
No, A is for inquiry, B is a notice.
Let me,
Yes.
I'll just try and highlight all these points to your lordship. The first issue is where the assessing officer has to conduct an inquiry, which is an internal nature of inquiry. Here, which we have conducted by giving a notice to JM Financial, and the JM Financial has in fact given us a response clarifying their stance.
So 148 A is satisfied.
Yes.
Now,
Now comes B,
yeah.
which is in tune to the principle of natural justice, where we have to provide them an opportunity of hearing, which has also been given to them because they have given their response. We have considered in light of their response.
D.
Now-
you have to read D now.
Yes. I will come on to C as well, where they consider the reply. D is decide on the basis of the material available. Here, I don't need to provide them the material which I've got against them. I have to frame a preliminary understanding first, then I have to collaborate it with the reply. And thereafter, I issued them a notice, which they have challenged. So, Lordship may kindly see the Honorable High Court has relied upon two of the earlier regimes' case understanding. In fact, Lordship, I have prepared a 2-page note as well for your Lordship.
Show the finding. We are not deciding. We'll decide on notice. Show the finding.
Yes, your Lordship.
Come to page.
Lordship, the relevant is at para 6 and para 5 and 6.
Change the course.
Yes, your Lordship.
Read that.
Para 5 reads as, however, the respondent has clearly changed course while passing the final order under 148AD by now alleging that the dividend has been received from sham transaction generated using the colorable devices. It is further alleged that by the respondent that the dividend has received is not on account of appreciation of investments and would not qualify as such. Para 6. It is thus ex facie.
Yes, my lord. My lord.
How is it
Just give me 2 minutes, my lord. Just give me 2 minutes. My lord,
come back.
First on the delay, my lord, look at the condonation.
1501.
Upon a cumulative reading of the aforesaid discussion and in the light of the Constitution Scheduled Caste Order and Constitution Scheduled Tribes Order, the following principles emerged for determining the entitlement of a person to be recognized as a member of a scheduled caste or scheduled tribe. Claimant must demonstrably belong to a caste or tribe which is specially notified and recognized under the constitutional orders. No person who professes a religion other than Hindu, Sikh, or Buddhist shall be deemed to be a member of a scheduled caste. This bar under clause 3 of the Constitution Scheduled Caste Order 1950 is categorical and absolute. Conversion to any religion not specified in clause 3 results in immediate and complete loss of scheduled caste status from the moment of conversion regardless of birth. No statutory benefit, protection, reservation or entitlement under the Constitution or under any enactment of Parliament or state legislature that is predicted upon any enactment of Parliament or state legislature that is predicted upon the membership of a scheduled caste can be claimed by or extended to any person who, by operation of clause 3 of the Constitution, is not deemed to be a member of the scheduled caste. This bar is absolute and admits no exceptions. A person cannot simultaneously profess and practice a religion other than the ones specified in clause 3 of the Constitution Scheduled Caste Order and claim membership of a scheduled caste at the same time. In cases where a person claims to have reconverted from a religion not specified in clause 3 of the Constitution Order back to Hindu, Sikh, or Buddhist religion, following three conditions must be cumulatively and conclusively established. Then we have set out the conditions. Where a person ceases to be a member of a scheduled caste by virtue of clause 3 of the Constitution Scheduled Caste Order 1950, the loss of such status carries with it the automatic and immediate termination of all eligibility for statutory benefits, protections, reservations, preferences, and entitlement that are predicated upon or flow from such membership. In the present case, it is not the case of the appellant that at any stage he had reconverted from Christianity to his original religion or has been accepted back into the fold of the Madiga community. On the contrary, the evidence on record unmistakably establishes that the appellant continues to profess Christianity and has been functioning as a pastor for more than a decade, conducting regular Sunday prayer meetings in different houses of the village. It is also an admitted position that at the time of the alleged incident, the appellant was conducting prayer meeting at a pastor at the house of one Damakoti Reddy. These concurrent facts leave no room of doubt that the appellant continues to remain a Christian on the date of the occurrence. Then we have dismissed this facility.
Grateful, my lord.
Yes, go.
Wait, please, Your Lordships. Your Lordship, this is that matter in which 4 deaths have occurred. Mentioning it, Your Lordship had kept it for 17th of March. That day, Your Lordship's list was heavy. Your Lordships couldn't take it up. This is that case, Your Lordships, 304A, that's negligent driving. Your Lordships wanted to see whether 1 year and 5 months, 6 months has been completed before Your Lordships hear us on merits. Your Lordships, that has been completed. So, Your Lordship, the next date is 21st of April.
Which matter?
Your Lordship mentioning Pantram.
Achha, mentioning.
This is that legal aid matter, Your Lordships. Maximum amount of sentence was awarded of 2 years under section 304A, and out of which 1 year and 5 months have already undergone.
So this is coming up on 21st April.
Would Your Lordships be inclined on having
It's a court fixed date.
Yes, no, Your Lordships, on the last date of hearing, Your Lordships could not take the matter up because the list was heavy. Your Lordships had precisely put it on that date because on that date, Your
You
Lordships,
should have asked for a date on that day.
Your Lordships, we requested the courtmaster, but then it was, the other side was not there.
So let it come on 22nd April.
Very well, Your Lordship. Otherwise, Your Lordship can have it on 1st of April because I have already undergone more than 1 year and 5 months also as of date.
Out of?
Out of 2 years.
Out of 2 years.
That's precisely why Your Lordships, in fact, had posted it on 17th of
You
March.
can prepone it for 10 days.
Yes, Your Lordship.
ठीक 8 April लगा.
Highly obliged. Grateful, Your Lordship.
802.
I will not deleted from the causes of 1st of April.
Coming on 1st April,
Yes.
not to be deleted.
Well, where is the
46.
One order has been passed because there is one small clerical error in that order inadvertently.
Which order?
Transfer petition consent term was there, an order was passed.
No, is it listed?
Malaj is not listed today.
Not, no, don't mention. I don't take non-listed mentioning. Yes. Yes.
46. Pass over.
Pass.
47.
Yes.
I succeeded in both the courts, Lord. The court reverses on the ground that, Lord, I did not pay the areas.
Yes.
So just see page 18, Lord. One paragraph, and beyond that, Lord, I will not question it. See page 18, Lord. Straight up. 80.
What is that?
The finding of the first court relying upon all the receipts which shows that I have paid all the areas.
No, that is not the requirement.
No, that's what the...
That is not the requirement, statutory requirement. See your 12(1)(a) of the MP.
Yes.
From MP.
Yes, let me-
12(1)(a) within 1 month you have to tender.
So, Lord, this very...
Either you have to tender one rent within 1 month of service of notice or appearance,
Yes, Lord.
or move an application under 13(6) disputing either the rate or the area.
So, Lord, the answer is this.
You have not done either of them.
No, the answer is this, Lord. This matter went to High Court in round 1.
Forget about
No,
High Court.
High Court permit me to deposit, Lord.
That High Court cannot condone.
Lord, nobody has challenged that order, Lord.
No. And High Court says in the second round
Yes.
that despite High Court order, you have not
Yes,
done it.
that's what I want to say. Just turn to page 81 paragraph. Page 18, Lord. Page 80, Lord. One paragraph. That High Court, Lord, is factually incorrect. Paragraph 16 at page 80, Lord.
No.
Permit, Lord.
You have to leave.
Lord,
You have violated.
all receipts, Lord, pursuant to the High Court.
You
order.
cannot subsequent payment.
No, that's,
Otherwise, earlier there was judgment that even if payment is tendered at the execution stage, it's
Even at
well and good.
appellate
But
stage.
thereafter, now the settled position under 12(1)(a) is
Lord,
because I come from 12(1)(a).
Lord, your worships are right. Lord,
Yes.
my only answer is this, that the High Court permitted me. I have deposited the finding in paragraph.
Time. What time you want?
Well, I'm running a small marble shop, Lord. But
What is
About
marble? You can take marble anywhere.
about 6 months, if your lordship can.
6 months, yes. This
Lords,
is-
Lords,
I
I
allow
appeal for
for
the respondent, Lords. My instructions are 2 months, Lords. Maybe.
Yes.
I have put
Lords,
that
What are your instructions?
Lords, 2 months may be granted to them for vacating the premises, Lords.
Yes, thank you. 6 months, yes.
Please.
48.
Without adverting to section 18,
Interim relief.
interim protection granted anticipatory bail, the learned session.
Yes, every day we are also granting.
Without.
Every day go and convince the court.
In fact, no adverting to section 18. Let's please have the impugned order for a moment.
Yes, we have seen that.
And two factual positions which are noted, which are factually incorrect. Please have first page 2
Yes.
at the top. Offence cannot be said to have occurred in public view, considering the fact that no independent witness.
Considering that the impugned order is an interim order and the prayer for bail is pending before the High Court, we are not inclined to entertain the SLP.
I then request one observation. Expeditious disposal, keeping in mind the mandate of the.
However, the High Court shall decide the main bail petition at the earliest. Next.
I am obliged.
49.
Yes.
Not in this case, my lord, the entire impugned proceeding are without jurisdiction. My lord,
Yes.
there is specific MP accommodation act, my lord.
Time.
My lord, let me for.
How much time you want? Three concurrent decree.
My lord, what else?
All the three courts.
My lord, I agree. My lord, but without jurisdiction, my lord, there is a bar of section 45 MP Act which says civil court cannot entertain this proceeding. My lord, they have to file before the rent controller. My lord, they have not filed. Their title is not clear. My lord, necessary parties are not there. My lord, without jurisdiction, my lord, how can RFA and RSA be maintainable? My lord, I ask myself, my lord. My lord, they were supposed to file an application before rent controller, my lord. That they have not done, my lord. Lord, without jurisdiction, how can this be maintainable otherwise, my lord?
Yes. Thank you. Dismiss.
Then, my lord, may give some time for eviction, my lord.
Yes. 3 months.
My lord, may give 6 months then, my lord. My lord, is the only sole earner for this.
Take 3 months. Other 6 months. 6 months.
Item 1.
Your lordship, I am appealing
Yes.
for the petition in this case. We are not pressing for the main prayers in this.
Dismiss the round paste.
Lordship, there is one issue which I want to point out. In the para 9 of the impugned order, there is a correct observation by the High Court stating that the matter was to be expeditiously disposed of
in terms of the application. But in the para 15 of the impugn order, that is an incorrect observation, and due to which the prejudice is now being.
What is that observation? Para 15?
In para 15, it has been said that in terms of the previous order of the Honorable High Court, the matter to be expeditiously disposed of is to be taken up. But at page 80 of my SLP, there is the order is annexed. The para 3 of that order clearly says that when an application is to be moved by the complainant, only then that is to be decided in terms of the expeditiously disposed of matter. But now, in terms of this para 15 observation, what has happened is that we had the matter has been proceeded for the defense witnesses. Only 2 witnesses have been examined. Now our other 4 witnesses have been closed in view of this. So just a mere observation on this point is being required.
What observation?
That para 9 observation is the correct observation.
Para 15 is incorrect.
Para 15 is incorrect, and
after your withdrawal,
Lordship,
you argue on merits, you will make observations.
Lordship, I can argue, but in this, I have been.
You cannot withdraw and then
I'm not
delete this paragraph, delete that paragraph.
Your Lordship can dispose of this matter.
The moment you withdraw, we have no jurisdiction to enter into the merits.
Lordship, then I can argue the case on merits,
Yes.
and your Lordship can.
Dismissed as withdrawn. However, the magistrate trying the proceedings under section 138 NI Act shall decide the matter on its own merits. Yes.
Lordship, the observation can be given and permit us.
Own merits.
Liberty
Everything is open.
Liberty can be given to examine the 4.
Okay, thank you. Thank you. Next.
4 other witnesses.
Lords, a letter for adjournment has been moved, my lords. Lords, a letter for adjournment has been moved, my lord. The district didn't place it, my lords. The arguing council was
Dismissed.
My lords.
Dismissed. You see, after you have got time from surrender, or rather you have been exempted from surrender, only adjournment has happened in this SLP. Only adjournment, nothing else. 4 times. Sorry, dismissed.
Item 3.
I won't trouble.
The interim order granting exemption from surrender is vacated. Yes.
He has already surrendered, but I won't trouble the merits of the case.
Yes, dismissed.
Item 4.
Yes.
Please, my lords, I read the brief of the petition, my lords, in this matter. Read the brief of the petition, my lords, was the plaintiff before the.
Yes, your suit is dismissed. Refund of 2 lakhs.
2 lakhs.
Enjoy that refund.
My lords may consider that power of attorney deed, my lord.
No, power of attorney is
Any discussion about
it's a fraud committed on the owner. You and GPA both have colluded to defraud the plaintiff. Yes.
My lords may consider the GPA.
Dismissed, nothing. It's a total fraud on the owner.
Delay may be condoned.
Rightly, yes, delay condoned.
Item 5.
Element of conflict and negligence also, my lord. And at page 56, considering that your lordship directed me to surrender, my lord.
Yes, we have issued notice.
This is
Issue notice. Returnable in 4 weeks.
I have been inside for 1 and
1 month more, then we'll decide it finally on that day. Yes. Date doesn't date. Issue notice. Post on 24th. 28 April. 28 April. Yes.
Suit for possession.
Suit decreed concurrently by all 3 courts.
Both are real brothers, lords.
Both are real brothers. You wanted your brother's property. How can it happen?
He was the Karta of the family. So
What Karta? You have not proved any single document, only electricity bill and water taxes. Nothing more.
Otherwise, all the expenses.
He has the sale deed, he has the loan document, he has the building permission, everything is in his favor. And there is no nucleus.
I have
Nothing, no jointness proved by you. Burden is on you to prove jointness, that you have failed and failed before 3 courts.
Could your office refer it to mediation, lords, at least some, because he is residing at some another district. I have the only one house.
Had it been a joint family property, mediation would have been successful. Otherwise, he is claiming his own property. Why mediation?
Lordship may kindly
Dismissed. Absolutely nothing.
Lordship may then grant me some time, at least 1 or 2 years to vacate me.
Thank you. Next.
7.
very short delay of 60 days.
Yes, delay control.
In this case, the High Court and the State Education Tribunal both have relied on the report of the Director of Education. Now, unfortunately, in the review petitions, with the 3 review petitions filed before the High Court, I had produced 2 documents. Namely, one, which was the audit report, which is
way back, you see, in 1991, that Shatrughan Jena challenged the report of the committee, wherein your name is not included. That report has been accepted, acted upon by the High Court. Thereafter, those 14 persons again preferred a petition. When that petition was allowed, you were not there at all point of time.
Party, that's what
not there means you did not prefer.
No. In the report, there is a report. Now, there is a counter affidavit filed by the state government itself saying that the report is not correct. Your Lordship, may just see one page, my Lord. The counter affidavit is page 221.
There are hundreds of pages against you.
No, my Lord, the only difference.
Only one page will not help you.
No, there are 2 documents which had produced. The High Court has not even referred to them and decided the review petitions. I just wanted to have a look at the two page documents which show that the report is not reliable. And if the report is...
A report which has been confirmed by the Supreme Court in 1989, 1991. You say in 2026 that the report cannot be accepted. Sorry, thank you.
My Lord, the High Court only says this.
Dismissed.
My Lords, there, the 7-point roster is...
There are 2 sets of additional documents.
Please, my Lords, the one filed on the cover page, my Lords, 11th February, it's written, my Lords, at the bottom.
That is the problem here. 11th February.
Please, my Lords. My Lords, may I have page 9?
Page 9. Yes.
My Lords, at page 9, my Lords, right on the top. My Lords, on the side, it is written 17. This is the roster. At the side, it says ST2. That means Scheduled Tribe 2. However, the respondent, that is Mayuri Naik's name is mentioned here. And on the right, it says whether belongs to SC, ST. It says neither. Below that, my Lord, my name is there, which should have been in 17, but it is written in 18. Sangeeta Kankonkar. And on the right, it says ST2. So, admittedly, my Lords, my name should have been in the 17-point roster, whereas it is mentioned in the wrong roster. That is what my entire case is. Now, my Lord, to just have the very next page.
No, but that appointment was made on 14/5/2018. Your appointment is on 14/9/2020.
Well, the case is not that. The case is that the ST Commission held that when the appointment should have been given to me, the roster also mentions my name. Thereafter, I should have been given. The High Court says there is no such roster, and I have not seen any such roster. That is the fact.
No, how can you be? It's only a claim regarding seniority. How can you claim seniority on a day prior to your appointment? We were appointed in September 2020. This document itself shows just below your name 14/9/20 is mentioned.
Well, subsequent to which the state government held me higher in seniority. And the respondent goes to the High Court. The High Court says that there is no such 17-point roster. It is not mentioned. This post is specifically reserved for me, my lords. In a reserved post, my lords, somebody who does not fall within the category has been given the post. That is the crux of the matter. If my lord would have the very next page of this, my lords, this is the Gazette notification at page 11. If I may just point out page 11, my lord. It's at the bottom, my lords, on the next column. It shows the paragraph number 2, 100-point roster to be maintained. And below, my lords, in serial number 2, Roman 2, it says...
No, which notification you are reading?
That was page 11.
Page 11, there are two circulars.
Please, the one on the left side at the bottom.
On the left side, Department of Social Science. 13/11, 13/14/90.
Please, my lords.
This number, yes.
Please, my lords. My lords, if my lords goes to the next column, on the next page, para number 2 starts with 100-point roster. And below that, my lords, it says serial number 1, scheduled caste, serial number 2, scheduled tribes. I fall under this. At the side, it says 4,17. So 17 is, my lords, specifically reserved for me, whereas some other candidate is put and thereafter they are appointed. My lords, the commission therefore goes into this and says that this ought not to have been done. The state accepts the recommendation. Today, the state is not...
No, but did you compete in the same recruitment?
Please, my lords. And the state accepts the recommendation, revises the list. What the High Court says is, my lords, in page 12, that there is no such roster.
High Court for the petitioner draws our attention to the roster point and the geodated 22nd April 2003 at page 9 and 10.
Page 9.
Page मत लिखना. Annexer P33 and P34 along with IA 49232 of 26 bracket additional documents to submit that petitioner belonging to ST category was entitled for appointment on the
Reserve
post at roster point number 17. However, on the said post, respondent Sangeeta Konkar, you are Sangeeta.
I am Sangeeta Manoj. Mayuri is
On the said post, Mayuri S. Nayak, comma, a non-reserved category candidate, comma, went and placed above the petitioner in the seniority list. Post up. Learned Counsel would further submit that the High Court has non-suited the has dismissed the writ petition only on the ground that the seniority list could not have been revised on the recommendation of the SC/ST Commission without examining the issue concerning roster point, issue concerning maintenance of the reservation roster on its own merits. Put stop. Para. Issue notice returnable on 14th May. Next.
Item 9.
There is a delay of 32 days to that.
Delay of
32 days in filing the matter.
Yes.
Labour Court awardment, 2 minute termination was found to be excessive.
You have been granted 1 lakh more by the High Court Division
The writ appeal, my lord. But only thing is, Mr. Amarnath, my lord, a trainee program or caste inspection given a report. He has not been examined. His report also not been marked. Now he is 54 years old.
Nothing can be done. Thank you. Delay condoned.
Delay
is 3 to 9 days.
Delay condoned.
May I please? Well, this arises out of the UP consolidation of holding that the respondents have not appeared, my lord, in spite of notice. My lord, in this case, after the statement of principles was issued under Section 8 of the UP Consolidation of Holding Act, the respondent filed an objection.
The state of UP is not appearing.
My lord, neither the private nor state, my lord, in spite of notice being served 13 years back through court.
Which department?
My lord, it's consolidation, my lord, so
revenue. Who is the boss?
Find out. My lord, we can find out and serve him. Otherwise, my lord, the issue that we are not going into.
The respondent, state of Allahabad, state of UP, has not entered appearance despite service of notice. Let the law secretary, state of UP, appear in person on 17th April. Let them appear. Why they are not ready to defend?
Yes. And then land matter valuable.
Yes.
That's all.
Item 11.
My lord, kindly pass over. Adverse possession not believed on the ground that
I'm appearing for the petitioner, Your Lordship. Lordships, the office report reveals that the service is not yet complete on the respondent number 1. Kindly give us 2 weeks time so that steps can be taken. Oblige, Your Lordship.
By this Honorable Court, Sajjan Kumar versus CBI as well as State of Orissa versus DN Padi, where they say that at the stage of framing of charges, now once the charges have been framed, let the complete trial begin, because what has to be seen is only a prima facie case. My learned friend herself said that one of the witnesses has turned hostile, but the other one hasn't. So then for that, the trial has to go further.
Your Honor, in this matter that I'm referring to,
Para 16 and 17, Ramesh Chand.
please, Your Honor.
Para 16, 17 you have referred
Yes, Your Honor.
and read also.
May I read it, Your Honor?
Yes.
This, so Your Honor, the relevant portion starts from para number 15. It's first of all, it says in this matter, Your Honor, the first FIR registered at the instance of the complainant is silent about the place of occurrence and who, being a member of the public, was present when the appellant is alleged to have heard caste-related abuses at the complainant. Similarly, Your Honor, in this matter, firstly, in the FIR, it is silent on the place of occurrence, on the fact that there was no member of the public present, and thirdly, what was the reason of the altercation. Your Honor, coming to paragraph 16, the first question that calls for an answer is whether it was at a place within public view that the appellant heard caste-related abuses at the complainant with the intent to insult or intimidate with an intent to humiliate him. From the charge sheet dated so-and-so filed by the IO, it appears that the prosecution would seek to rely on the evidence of the 3 witnesses to drive home the charge against the appellant of committing offences under section 323 and 504 and section 3 subclause 1 subclause X SCST Act. These 3 witnesses are none other than the complainant, his wife and the son. Neither the first FIR nor the charge sheet refers to the presence of a 5th individual, a member of the public, at the place of occurrence. apart from the appellant, the complainant, his wife and the son. Since the utterances, if any, made by the appellant were not in any place within public view, the basic ingredient for attracting section 31X of the SCST Act was missing/absent. We therefore hold that the relevant point of time, incident of hurling caste-based abuses at the complainant by the appellant, no member of the public was present. Your Honor, it is the case of the complainant himself that only the two of my childhood friends were present. And Your Honor, there is one very interesting thing that to be noted. He states in his complaint that from the last 1 year, these instances have been happening, yet he is unable to cite one witness who is independent, who could corroborate the case of the complainant. Your Honor, coming to paragraph number 17, that apart assuming arguendo that appellant had heard caste-related abuses at the complainant with a view to insult or humiliate him, the same does not advance the case of the complainant any further to bring it within the ambit of section 31X of SCST. We have noted from the same during the course of verbal altercation as to the caste to which the complainant belonged, except for the allegation observation that caste-related abuses were heard. The legislative intent, Your Honor, coming to the concern of learned counsel here, the legislative intent is started.
Let us again read the FIR.
Please,
Page 34. What is the exact place here in this case?
Just a second.
In your case. Page 34. In our case.
Your Honor, may I read it?
Yes.
Firstly, so if I have to start from the top.
We only want to know what was the place.
It is silent. I'll just read it. I'll read the relevant part. My lords, sir, today when my friends came to meet me, Gunjan used all these caste indicative words in front of them too. My friend Chandra Prakash alias Tini has also seen me get abused. Your Honor, the translation is wrong here. Who comes to meet me, and in front of him too, Gunjan Rachna used caste indicative words. He has also been abused many times in front of my friend Bobby, and Gunjan has called me so and so in front of him. Your Honor, this is the only allegation. It is silent on the place of occurrence. It is silent on the reason of the altercation. And Your Honor, one very interesting thing is that both the witnesses subsequently during their interrogation specifically state that the cause of altercation was over breaking open the lock of the house of the accused persons.
It is inside house.
Inside.
It is, please, Your Honor. And secondly, if we were to
Whenever they used to come outside the house, so it is not.
Just one.
We are closing it.
Can I just show page 55?
Yes.
The charge sheet.
Yes.
The four, my lords. So out of the two witnesses, one has turned hostile, the other one has supported the prosecution case, the complainant story.
Yes.
Please have page 54. And this is what he says. Question number 1. You have not told anything about caste remarks in your statement when Bhimsen in his complaint, his brother so-and-so, spoke in front of you by abusing him about his caste, whether this thing is true or not. If it is true, then when and at what time did Gunjan say abusive words about caste to Bhimsen? Then he says, Chandraprakash, when we went to Bhimsen's house, Gunjan had said caste words to brother while standing in the street. And then he says what words were used. So this is at the stage of investigation during the charge sheet, and this person hasn't turned hostile.
But come to page 33.
That's in the FIR. That's correct.
In the FIR, in the body, the place is not mentioned.
Correct.
But if you come to the format of the FIR, page 33. Page 33.
Yes.
Annexure P1 FIR, opening page. Come to clause 5.
Yes, sir.
Place of occurrence.
It's not mentioned there.
It is mentioned. Place of occurrence A, small a, distance and direction from PS so and so. B, address 7/38 Ramesh Nagar. This is the house of the complainant. It is inside the house. It is not said that opposite to or on the street in so and so mohalla.
What has been avoided?
It is the house number of the complainant. Yes, close for order. Third and counsel for the parties, close for order. Parties may submit written submission within 1 week.
We'll consider.
But FIR is not an encyclopedia of what I will submit. And when the address is mentioned, it was the complainant's address but it does not say that exactly where the instance has occurred. And that is why the investigation by the agency and the investigation, this one witness who hasn't turned hostile very clearly says that it was on the street. And that is why the public view is my argument, Tyler.
Yes.
Tyler, 3-page.
Yes.
Please, I'm grateful. I'm obliged. Item 16.
Letter adjourned.
Obliging.
Item 17.
Please, Your Lordship. My Lords, in 17, I appear for the state. In terms of my Lord's last order, we have completed the charge sheet. My Lord, we have completed the investigation. Charge sheet has also been filed in the concerned court, my Lord, on 16th of March. Now it is listed on.
What is this about?
This was, my Lords, against the interim order passed by the High Court, wherein the stay granted on the investigation has been against.
So that the High Court has stayed the investigation.
Correct, my Lords.
And we have stayed that order.
Now it has been completed.
So now charge sheet is filed.
So nothing remains in this.
We'll take it on some other day. Learned Counsel for Respondent State informs that upon completion of investigation, the charge sheet has already been filed. And thus the pending before the High Court has been rendered infructuous.
My Lords may not say before the High Court because they may have something to say in that.
Pending before the Honorable High Court matters.
Mhm.
My Lords, the charge sheet, if they wish to produce, they can this week.
Requirement first before the concerned court, they will be summoned.
Instant SLP has been rendered infructuous.
Please, my Lords.
High Court का मतलब ना? Full stop. On 22nd April.
Deeply grateful.
Item 18.
Item 18 has later. Today, we get a letter for a week's time.
Just a minute. After notice. Yes. 19. Yes.
Those were it. Hello, led by Mr. Sibal, I'm seeking a short pass over there.
Yes, come, yes.
Yes.
As your Lordship will remember, last time I was referring to the reliefs sought in the petition.
Ah, yes.
That's where we ended.
Mhm.
My Lord, be kind enough to look at that.
Yes.
Hmm? 46.
Yes.
Issue a little mandamus. If I got it. Hello, Justice Anjali.
Issue mandamus, yes. Page 46.
Mandamus directing the CBI to register FIRs and investigate the entire incident in relation to the obstruction of ED's search conducted on 8th of January 26 at both the residential premises of one Mr. Pratik Jain as well as the office of Indian PSC Consulting Private Limited, Ipac, described in detail here above, including the role of the present respondents number 2 being the Chief Minister of West Bengal, Commissioner of Police, Calcutta, Director General of West Bengal Police, other police officials, and all persons acting in concert. So, whereas your Lordships will have to find, as a matter of fact, that the ED has a fundamental right to seek this prayer. Because ED is the petitioner, Malas. So,
yes.
An entity has a fundamental right to seek a prayer under Article 32 for the purposes of another agency of the central government to investigate a matter. It's a proposition of law, Malas, that has not been canvassed and upheld in any court so far. 2. Direct immediate seizure, sealing, forensic preservation, and restoration to lawful custody of the Enforcement Directorate, all digital devices, electronic records.
It can be a little more loud, Murali. Voice is not coming.
Oh, I'm sorry. I thought I'm normally loud, but I'll be louder. Direct immediate seizures.
Not for him, he says.
Well, he is such a gentleman that he seldom hears.
No, they need, and they want you to be more. Yes.
Direct immediate seizure, sealing, forensic preservation, and restoration to lawful custody of the Enforcement Directorate, all digital devices, electronic records, storage media, and documents illegally and forcibly taken away from the search premise. Then see, issue a writ of mandamus commanding the respondent number 1 to 5 authorities, restraining the state authorities from interfering with the proceedings under the MLA. Now, this is a different kind of prayer. The first 2 prayers are a mandamus, as to who should investigate the matter and whatever documents according to them were taken by them, return those documents. But C is issue a mandamus commanding the state authorities from interfering in proceedings under PMLA, restraining the state authorities from interfering in proceedings under PMLA. And transfer FIR number 3, registered in Shakespeare Sarani, whatever, dated 8th of January, registered in Electronics Complex, and any other FIR registered against any officer of the enforcement with respect to searches conducted on 8/1/2026. Now, Malad, this is a prayer seeking, Malad, that the FIRs registered on the basis of the conduct of the ED officials, those FIRs, Malad, should not be proceeded against. And Malad, those and your lordships have already stated them. So, Malad, this is on the premise, Malad, that if an employee of the central government or an officer of the enforcement agency commits an offense within the jurisdiction of a political police station in a state, then that offence cannot be investigated. This is on that premise. Right, Mullahs? Luckily for us, we have a judgment recently by this court, Mullahs. Justice Parliwala judgment. Can you just speak to me? It just happened the other day. Naval Kishore. Mullahs, I tell your lordship the brief facts in that judgment. Mullahs, an officer was alleged to have, Mullahs, sought a bribe. Officer of the central government was alleged to have sought a bribe, Mullahs. And he was sought to be prosecuted, and he was an employee of the central government in the state. And the question arose before the court, can he be prosecuted? Because he's an employee of the central government. And Justice Parliwala, Mullahs, held, yes, he can. Merely because he's an employee of the state, it really doesn't matter. So the proposition is that an offence is committed by the state, by an officer of the central government, in a state where the situs is within the police station, jurisdiction of that police station, that investigation must go on. Right? So that's what it is. But you have to get to the what even told them.
You mentioned the citation, we'll write it. We'll take note of it.
2026 SCC online. What sent it to me? 2026 SCC online, Supreme Court 103. And the cause title is Naval Kishore Meena versus State of Rajasthan. Paragraph 6 and 7. I'll read it, Mullah.
Yes, please. Yes, please.
Section 156 of the CRPC, falling within Chapter 12, deals with powers of the police officers to investigate cognizable offences. Subclause 1 of Section 156 says that any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of Chapter 13. Subclause 2 of Section 156 of the CRPC says that no proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Section 4 of CRPC deals with the trial of offences under the Penal Code and other laws. Subsection 1 of Section 4 says that all offences under the Code shall be investigated, inquired into, tried, or otherwise dealt with according to the provisions of the Code. Subsection 2 of 4 of Section makes it clear that all offences under any other law shall be investigated, inquired into, tried, and otherwise dealt with according to the same provision, but subject to any enactment for the time being in force, regulating the manner or place of investigating, inquiring into, trying, or otherwise dealing with such offences. The Code of Criminal Procedure is the parent statute which provides for investigation, inquiry into the trial of cases, and unless there is a specific provision in another statute to indicate a different procedure to be followed, that's a different procedure to be followed, the provisions of CRPC cannot be displaced. In other words, the existence of a special law by itself cannot be taken to exclude the operation of CRPC unless the special law expressly or impliedly provides a separate provision for it. The general provision under 156 shall prevail. Now, the PC Act is a special, now it goes to the issue. The PC Act is a special enactment enacted to deal with the bribery and corruption. Going by Section 4.2, read with 156, the provision of CRPC shall be applied to the extent that they are not inconsistent with the provisions of the PC Act, which being a special act, will deal with all kinds of offences committed under it. Section 17 of the PC Act deals with investigation into cases under the Act. It is extracted here under for easy reference. Then Section 17 is extracted, I won't read that. Then straight away, they refer to the PC Act. The PC Act does not specifically envisage a separate procedure for conducting investigation. The offences under the PC Act can be investigated into by the state agency or the central agency or by any police agency as can be seen from section 17 of the said Act, with the qualification that the police officer shall be of a particular rank. Section 17 does not exclude or prevents the state police or a special agency of the state from registering a crime or investigating cases relating to bribery, corruption, and misconduct against central government employees. So you can register a crime if a crime is committed within the jurisdiction, even if it is a central government employee. It is for the convenience and to avoid duplication of work that the CBI, a specialized investigating agency under the Special Police Establishment Act, is entrusted with the task of investigation of cases of corruption and bribery against the employees of central government and its undertakings. And the Anti-Corruption Bureau, a specialized investigating agency of the state, is entrusted with the task of investigation of cases of corruption and bribery against the employees of state government and its undertaking. As stated above, Section 156 of CRPC authorizes any police officer in charge of a police station to investigate a cognizable offence without the order of the magistrate. The word police station has been defined in Clause S of Section 2 of the Code to mean any post or place declared generally or specially by the state government to be a police station and includes any local area specified by the state government in this behalf. The Vigilance and Anti-Corruption Bureau is also a wing of state police. The offences under the PC Act are also cognizable and can therefore be investigated by the state police or VACB, that is the Anti-Corruption Bureau. The only rider is that the investigation can be done only by a police officer of the rank specified in Section 17. As per Section 22, therefore, the provisions of CRPC shall apply, save and except the specific areas envisaged by the Act. A similar question came up for consideration before this court as early as 1973. That was a case where a crime was registered against the accused under Section 5(2) of the PC Act by the Anti-Corruption Department of Delhi Administration. After investigation, the final report was filed. The accused was tried before the Special Judge Delhi, and he was convicted and sentenced to undergo imprisonment. His appeal was dismissed by the High Court. He challenged the conviction and sentence before this court. The main ground urged by the accused before the court was the Delhi Special Police Establishment Act, as amended, prescribed special powers and procedure for investigation of offences of bribery and corruption in the departments of the central government. And as he was an employee of the Central Works Department, and offences against him could only be investigated by the SPE, established under the DSPE Act, the investigation having not been done by the Delhi police, his trial was vitiated, contended the accused. This court, after evaluating the rival contentions, held that the scheme of the Act does not either expressly or by necessary implication divest the regular police authorities of their jurisdiction and power and competence to investigate into offences under any other competent law. It was further held that the DSP Act seems to be the only permissive or empowering, intended merely to enable the Delhi Special Police Establishment Act also to investigate into the offences specified and contemplated by Section 3 without impairing any other law empowering the police authorities to investigate offences. The Central Bureau of Investigation has also been constituted by notification. And then ultimately the court held that the state can. Now, in this case, an FIR has been registered for cognizable offences that have been committed within the jurisdiction of a police station. And therefore, to say that cannot be investigated, be contrary to the law laid down by this court, and I request your lordships that stay should be vacated. So, that's on the prayers that I mentioned. Now, kindly, we were talking about the fundamental right of the Enforcement Directorate. My learned friend, Mr. Diwan, has already amply argued that matter most effectively. So I'm not going to waste your time on it. But kindly have a look at the petition and the cause title. Now, kindly have most inefficient. let us kindly see the cause type of this petition. Kindly see. Now let us kindly see. Directorate of Enforcement being represented by Deputy Director. Just mark that. Being represented by Deputy Director.
Yes.
Directorate of Enforcement, New Delhi, having its office at Pravartan Bhavan. And Robin Bansal, son of Rakesh Bansal, aged 38, currently working as Deputy Director. So, Malad, he is the Deputy Director through which the petitioner number 1 is moving. And Rakesh Bansal is the Deputy Director who is Malad's currently working. Now, Malad, this Deputy Director was nowhere. He was nowhere in the scene. He was nowhere in the scene, Malad. So how does this petition lie? This is the enforcement of a fundamental right. So this is not a public interest litigation. A person, Malad, who moves the court under Article 32 has to specifically set out which fundamental right of his has been violated. Right, Malad?
Yeah.
A person who is not on the scene, who is not at the premises when all this allegedly happened, can't espouse the cause of alleged fundamental rights of others. At least, Malad, as a proposition of law, I have not heard, Malad,
Yes.
that a person in an habeas corpus petition, yes, the wife can file, Malad. But there is not a reference to the presence of the Deputy Director in the entire petition.
19.1 then? Yes.
Now, whereas what he has done is authorized other officers to go there. Right?
Yes.
That's only an authority given by him. And your lordships will see throughout. There is no reference to Rakesh Bansal.
No, he is Robin Bansal.
Robin Bansal. Yes. Son of Rakesh Bansal. Yes.
He was not there on the spot.
No, he is not there on the spot.
On the date of incident, whatever.
He was not there. But he was doing good for others because his name suggests it's Robin Hood.
But he is only Robin.
He is only Robin, unfortunately.
Minus Hood.
Yes.
Actually, there are some. I will point out factually what is the position. He may say that he was not present, but I have something to add. I will add.
No. If you mention which paragraph he is present, you have mentioned it is his petition.
I will point out.
No. If you say, if I am wrong factually, I will say.
Maybe a shadow officer.
I'm sorry?
Maybe a shadow officer.
Nowadays, there's lots of shadows going around nowadays. Yes. We just hand over that judgment, that I cited. Because this is very important, from the point of view of the very basis of this petition.
Yes. This you have already read, no? This Naval Kishore.
Yes, I've already read, I pointed out those paragraphs also to your lordship. Paragraph 6-7.
Yes. 6-7, yes. We have noted para 6-7.
Paragraph 6-7, 9.
9 also? 9 and 10.
7, 9 and 10. 9 and 10. That's very important.
Yes.
So, the one of the submissions that I am making is, that the person who has filed the petition has not claimed any fundamental right. Not only that, assuming whether I have a fundamental right. Let's assume for a moment then the petition must state which fundamental right has been violated. Who is the petitioner? Not for anybody else. So there are two steps to be followed. One, I have a fundamental right. Two, which right has been violated? That is my right, the right of the petitioner. Both are missing.
Yes.
Right. Now, the second issue. I will cite a judgment to your lordships. State Trading Corporation versus Commercial Tax Officer. I hope you have that. This is 9 judges, Mullahs. In that case, the State Trading Corporation moved the court under Article 32. And the question arose as to whether they can move the court by claiming that there is a fundamental right. Your lordships may see the questions. The two questions are set out at page there's no pages here.
Very first paragraph. Very first paragraph.
Just write your mothers in the beginning. Justice Sinha's mothers. Okay. Oh, I see. All right, page 3, yes, right on top. Now let's kindly see whether the State Trading Corporation, a company registered under the Companies Act, is a citizen within the meaning of Article 19 of the Constitution and can ask for the enforcement of a fundamental right guaranteed to citizens under the said article. And 2, whether the State Trading Corporation, notwithstanding the formality of incorporation under the Indian Companies Act, in substance, a department and organ of the Government of India. Well, let's just pause here. This is exactly what is being sought to be argued. Department and organ of the Government of India, with the entirety of its capital contributed by the government, and can it claim to enforce fundamental rights under Part 3 of the Constitution against the state as set out, as it should be, in Article 12 of thereof. Now, the 9 judges, mothers, answered this question, rejecting, mothers, the enforcement of the fundamental right of State Trading Corporation, saying that there is no such right. Now, mothers, kindly come to page 35. You'll see that page, mothers, right on top of the small printed.
Which page?
Page 35. Right on top, you will see, mothers, if you notice, right on top, there's a little small, after SEC, online under that, page 35. Yeah, on the left side.
The headnote side.
You must request this SEC online publishers to print this page number.
Correct.
Some different place. You can speak to them. Because every time SEC online is cited, we need at least 1 minute to search where is the page number.
I know. And it also strains the eyes, mothers.
Yes, yes.
Anyways, at the bottom, paragraph starting, this is not to say, at the bottom of 35,
yes.
This is not to say that corporations have not been given any protection under our Constitution. Unlike the Constitution of the United States of America, our Constitution does not overlook corporations. The General Clauses Act is applicable to interpret the Constitution, and that Act, as has been pointed out already, defines person as including corporations. The following articles of the Constitution employ the word person, which applies equally to individuals and to corporations. So when it comes to Article 14, Mullahs, a person can invoke Article 14, and a person will include a corporation. But that is where an act against the state, Mullahs. That will not apply here. If the state does something, Mullahs, then of course, the corporation can say, 2, Article 20, in respect of conviction for offences. Of that, whether the companies are convicted under some special statutes. So they will have a right, Mullahs, to move. 3. Freedom as to payment of taxes for promotion of any particular religion. And compulsory acquisition of property. So, Madad, except in these 4 cases, Madad, even a person cannot move. Right? Even a person cannot move. A person cannot move under, well, it's 19. He has to be a citizen. Corporations are not citizens. So 19 doesn't apply. In this case, 14 doesn't apply. In this case, 20 doesn't apply. And the argument is 21. Deprivation of liberty. That's the other argument. They say 21, 14, 21 and 22 is what they say. That's set out, Mullahs, in paragraph. I'll show that straight away from the petition. So
No, there is no paragraph.
there is a paragraph on this in the petition.
So in the petition, I thought in the judgment.
What is the fundamental right, Mullahs, that they are claiming? Page 40, Mullahs.
14, 19, 21, these 3 they are claiming.
No, Mullahs, they are claiming 14, 21 and 22. 19, Mullahs, they can't. Individual, yes. For that, I've already given the answer.
Yes, 14, 21, 22.
And Mullahs, even when individual, Lordship may know that, the individual only can claim the right where his fundamental right that has been violated. Mullahs, there may be 10 people involved, Mullahs. If I come to court as Robin Bansal, then I must say what is that right of mine, which is a fundamental right which has been violated. I can't talk about others. That is beyond the petition. So even if Robin Bansal were to be taken as a petitioner, only his case will be examined by the court. The court will not examine the fundamental rights which have been breached by any other. And you have none of this here. And so, Mother, your losses will para 40.
Yes.
Because the impugned acts violate the fundamental rights of the officers of enforcement.
Para 40 of this?
Para 40 of the petition. Sorry, page 40, sorry. No. Page 40 of the petition.
Yes.
Yeah.
Fundamental rights can always be person-centric.
Sorry?
Fundamental rights are always person-centric or citizen-centric. They can't arise in abstract situation, in the context of situation.
Yes, absolutely.
They can arise.
Yeah.
Fundamental rights can arise in context of a situation. In abstract, need not be a person-centric always.
No, Mother, I'm sorry, Mother, that is interpreted by this court by 9 judges now, Mother. Only in respect of these 4 articles.
Say rule of law. Is it not a fundamental right to have a rule of law in general?
Yeah, but if I say there's a violation of a rule of law, I have to say which violation? No, I'm not disputing what my Lord is saying. If you say there's been a violation of the rule of law, the next question is which violation? Next question, whose violation? Then what are the material particulars of that violation?
That is contextual.
I'm only talking about that. What's the context here? I'm not disputing what my Lord is saying. Rule of law is reflected in what? In Article 14, Article 15, Article 16, Article 19. These are all part of the rule of law. I'm not disputing any of that. Of course, they can be enforced. Question is who can enforce them? 19 can only be enforced by a citizen. Can you say it can be enforced by anybody?
In the larger context, the basic features which are carved out in the case 1 and part, are they not a kind of fundamental rights?
But that is basic feature for protection, Mother. Then that is the basic feature of the Constitution. Whereas federalism is a basic feature of the Constitution.
So in that context, the right can arise.
But how does this arise, Mother, in this case?
That is a different thing.
But I'm only talking about this case, Mother.
That's it.
I mean, tomorrow, Mother, for example, if a gas tragedy takes place like it took place, Mother, in Bhopal, then there is a parents' patriot jurisdiction available, Mother, their fundamental rights, but then they can't move the court. Therefore, a parents' patriot jurisdiction is there. Because millions of people or thousands of people or lakhs of people who've been affected by the Bhopal gas tragedy had no capacity to move the court. So the court takes over and Mother, the spouse is their cause. You're right. But that's not this case. So your Lordship is right on the fundamentals, but you have to apply the fundamentals to the facts.
That is what we are deciding with the help of all of you.
That's precisely I'm trying to help you this. It is my endeavor to help. That's the whole point of this. I was at the moment saying the Supreme Court has not finally decided that these are the State Trading Corporation was said that even a department of Government of India cannot file a petition, but we are talking about a Directorate of Enforcement. Number two, that your lordships may note, that the appointment of all the officers, even the Deputy Director Robin Bansal, is by the central government, not by the Directorate of Enforcement. So, Manoj, if any right has been violated, either Robin Bansal himself or the central government is the aggrieved party, not the Directorate of Enforcement. Now, why have they made Director of Enforcement the petitioner? Because the central government can't move under 32. They can only move under 131, which argument has already been addressed. The lordships must note that the appointment is only by the central government. So if a deputy director appointed by the central government is aggrieved, then either the central government is aggrieved or the individual is aggrieved. So if at all, Manoj, a petition can only be filed by the central government, but that can't be filed under 32, nor under 226. Anyway, so, and another place they have said that our right under 14 is violated. That's the other.
40 and 41.
14.
40 and 41.
No. Their fundamental right apart from 21 and 22, also 14. They have alleged that their right under 14 has also been
There are
25.
They are at two places.
Yes, I'm just showing that.
Page
yes. 25.
First at page 22 also. 22 clause.
Yes, 14, 21 and 22 as I mentioned to your lord.
Yes. And then page 40 and 41. Again they have mentioned what are the rights violated.
That's right. That's 21 and 22 again.
Yes. And then next page, top of page 41.
Yes.
They have mentioned 14 and 21 again.
That's right. So I am myself saying that 14, 21, 22. Those are the three rights that they are talking about. And 20 and 21 and 22, Madhas, again, those doesn't arise for the simple reason that the third aspect, Madhas, which your lordships might consider, yes. Now, there's after the State Trading Corporation, because it was a 9-judges judgment, and they answered the two questions. Actually, they answered only the first. Justice Hidayatullah, which judgment I did, answered both questions. The matter was sent back to 5 judges, and that's this judgment, Telco versus State of Bihar. Just give it to my lord.
Yes.
My lord got the judgment?
Yes.
Now, let's kindly come to page 13, let's at the bottom. Last 3 lines.
Yes.
Last 3 lines.
Yes.
Once a company or a corporation is formed, the business which is carried on by the said company or corporation is the business of the company or corporation, and is not business of the citizens who get the company or corporation formed or incorporated. And the rights of the incorporated body must be judged not on that footing, on that footing, and cannot be judged on the assumption that they are the rights attributed to the business of individual citizens. Therefore, we are satisfied that the argument based on the distinction between two rights guaranteed under 19(1)(c) and G and the effect of their combination cannot take the petitioner's case very far when they seek to invoke the doctrine that the veil of the corporation should be lifted. That is why we have come to the conclusion that the petitions filed by the petitioners are incompetent under 32, even though in each of these petitions, one or two of the shareholders of the petitioning company or incorporation have joined. They said, look, the shareholder has it right, certainly he is a shareholder of the company and therefore he can sue under 19.
No, but that is not your submission. That was not your submission. You say that Mr. Diwan says it is not a body corporate. It is neither a company.
Yeah.
It is neither a department of the government,
Correct.
according to you.
Correct.
So this judgment is in terms of a company or an incorporated body. That is not your case. Because you say it is not a company, not a body corporate. It is neither a government.
I am not.
It is only a directorate of the government.
I'm giving an alternative submission, Mullah. My learned friend has argued on that. I'm not going to repeat that. I support that. But I'm giving an alternative submission. In any event, Mullah, they cannot sue. That you can't implead, Mullah, an individual in this case when you are moving through the enforcement directorate. He didn't argue the point of the fact that under the act they are appointed by the central government. Right. I'm only saying, well, here, if at all, it is the central government that can be aggrieved. And the central government can't move under an individual because the central government itself cannot file a 32 petition. So therefore, how can it move under an individual? And if you accept what Mr. Devan has said, that there's an enforcement directorate, it's not a department of the government of India, in any case, it cannot move them. The fact that there's a petitioner number 2 doesn't make a difference, Mullah. That's the point that I'm making here. So it's not,
No, you see, you cannot equate the petitioner number 2 with a shareholder. That is what we are doing.
No, I'm not equating. No,
By reading this, you are trying to
that's a shareholder.
make out a point that since if the company cannot maintain, shareholder cannot maintain, therefore, if petitioner number 1, ED cannot maintain, officers of the ED also cannot maintain, that is your submission in...
No, I think I misunderstood. I'm saying in this case, it's on a higher footing because the shareholder is a citizen of India. The shareholder is a citizen of India. He is now claiming that forget about the corporation, I can't move under 32. I, as a citizen of India, can...
Yes, we have taken it.
That's all I'm saying. Yes. I'm not saying anything different. So, Malas. So now I've finished with this. Then let's kindly come to... Now, Malas, on the proposition, Malas, that they say that the CBI, that the case being investigated in West Bengal should not be investigated by the state police. Right, Malas? Now, that is covered by several judgments of this court. And your lordships may just note those judgments, and I'll give them to you. There is Sakiri Basu, which is 2008 to SEC 409. I'll give those judgments to your lordship presently. 409, paragraph 131. No, page 131.
Para or page what?
No. Para is 26, 27, 25, 26, 27, 28. Just give. The proposition is the following. Let's leave these judgments out. Proposition is the following. I have a remedy If any of my rights have been violated, I have a remedy under law. What is that remedy? I can move the magistrate. If an FIR is not being registered, I can move the magistrate. Magistrate can direct a 156(3), as your lordship knows. Magistrate, if supposing that is somebody is aggrieved by that, you can file a 226. In 226, the court has ample power to pass any orders for the purposes of investigation. Even the officers of investigation can be decided by a 226 petition by the court itself saying, look, I'll have it investigated in this way or that way. I'll have an SIT or I'll have certain officers, which has been done several times, both in this court and otherwise. So, there is a remedy available. So, what is this 32 petition for? There is a remedy available in law. So, why do you have to file a 32 petition?
Yeah.
The second judgment is Romila Thapar versus Union of India. I'll just give you also the pages so you don't have to waste time.
Yes, yes.
That is 2-1. I'm giving your lordship the citation. You hand it over. And there the paragraph is para 30. And then there is CBI versus Rajesh Gandhi.
Romila Thapar is page para 30.
30 minutes. Just give me a read of the little bit. Rajesh Gandhi. In that paragraph, number is okay. Leave it, Mother. That's my date. My friend said here.
With para number of Rajesh Gandhi.
Mother, actually, of all that para 30 says, the consistent view of this court is that the accused cannot ask for changing the investigating agency or do an investigation in a particular manner, including court.
Yes, yes.
The principle that your lordship are aware of. I don't have to trouble your lordship so that. Now, let's kindly see. Now, the next proposition is Article 32 cannot be invoked for enforcement of statutory rights. But there is a statute. In terms of the statute,
CRPC.
Sorry?
In terms of CRPC.
Yes.
156(3) CRPC.
No, even otherwise, if there's a particular statute which says this is going to be the mode of investigation, you must go under that statute. Right, Melissa? Now, in this context, I'm going to show some judgments, but in this context, Melissa, kindly see section 66(2) of the PML.
Yeah, PMLA. Yes, 66(2). Yes.
Yeah. If the director or other authority specified in subsection 1 is of the opinion, on the basis of information or material in his possession, that the provisions of any other law for the time being in force are contravened, then the director or such authority shall share the information with the concerned agency for necessary action. Right? Now, let's see the petition for a minute.
Which is this agency? Concerned agency?
The state police. The state police, wherever the offence is committed. Well, let's kindly see. Let's elaborate the proposition. Whereas I go into a state or I'm investigating proceeds of crime. Already investigating proceeds of crime in respect of a predicate after a predicate offence has already been registered. In other words, because proceeds of crime only come after an FIR is registered. So, the deputy director of the director, goes and investigating a matter in which an FIR, where proceeds of crime in which an FIR is already registered. He finds that some other offences have been committed.
No, it is not some other offence. It is only in respect to 66(1)(1).
Yes, I'm saying one is the same.
Two is referable to 66(1).
No, that's right. But
that concerned agency.
No, please, let's read it.
Concerned agency means agency which is referred for this.
I'll read it presently, Director or any other authority specified by him by a general or special order in this behalf may furnish or cause to be furnished to any officer or authority or body performing any functions under any law relating to imposition of tax. We are not concerned. Leave that out. 2. Such other officer or authority or body performing functions under any other law as the central government may, if its opinion it is necessary to do so in the public interest, especially by notification in the official gazette. In this behalf, any information received or obtained by such director or any other authority specified by him in the performance of their functions under the Act as may be, in the opinion of the director or other authority so specified by him, be necessary for the purposes of the officer or authority specified in subclause 1 and 2.
It doesn't apply this.
Right?
66 has no application.
No, but it has been decided in this court.
It has no application.
Please read it with me.
You have read it.
If your lordship,
we are of the view that it is not.
I'm trying to show to your lordship that that's not.
Yes.
If the director or any other authority specified in subsection 1, not 2, is of the opinion. 1, kindly read 1. 2 doesn't apply. 1 is an officer or authority or body performing any functions under any law relating to imposition of tax, duty or cess, or to deal in foreign exchange, prevention of illicit traffic in narcotics, drugs, psychotropic substances, under the narcotics drug and the psychotropic substances. Right, Manas? It is only in these questions. When he is investigating a psychotropic substance case, if the director or other authority specified in subsection 1 is of opinion on the basis of information or material in its possession, that the provisions of any other law, that is other than the psychotropic substances, other than illicit traffic, other than foreign exchange, please appreciate it has nothing to do with 2. And it's settled law. Your lordship, I'll show that. That's the case. I'll show to your lordship any number of judgments. So if he's investigating a case under tax, or he's investigating a case for duty or cess, or dealing in foreign exchange, and he finds that some other offense has been committed, he has to go to the state machinery. That's the law, mothers. They are here I hope, mothers, I'm making my point. They are here investigating what? Proceeds of crime in respect to what? Oath scam, for which an FIR is registered. In the course of that investigation, they find that some other offense has been committed. Under 66(2), they have to refer it to the state. Right? And what are those other offenses? Just see the petition.
You want that if the CM barges in and CM commits any offense, the ED will inform the state government, which is headed by the CM. If the chief minister barges in, commits an offense, obstructs the ED what is required to do according to your submission is that ED will inform the state government whose chief minister has barged in. That is your argument. We have understood. We have understood your argument.
Lordship are getting upset for no reason.
No, I am not.
Let me explain.
We are just trying to explain you that we have understood it.
No, your lordships haven't. Because your lordships are now saying that you are assuming that the CM has committed offences.
No, we have not.
You are.
That is the fact.
Well, how is it the fact? It's an allegation.
That is allegation.
So don't say it's a fact, Manoj.
Yes, you are right. It's
That's all I'm saying, Malad. There's nothing more. Once your lordship
These are the-
once or twice.
Don't mistake us, Mr. Sibal.
It's an allegation.
And allegation on us?
No, it's an allegation by them against the chief minister.
Yes, that is the allegation.
Not a fact.
And that is
Which is published every
because
week
of that
in the
allegation,
television.
we are here, all of us
The
are here.
Honorable Chief Minister comes on the media and says that yes, I have collected every evidence which is gathered by the.
It is not a fact, is what I'm saying, though. It's an allegation.
Yes, it's an
Right?
allegation.
So you can't assume that.
Allegation is always.
Now, Malad, let me explain. Forget the CM for a minute. We're interpreting.
No, we have not. I have not said against CM. Since you are accusing that the moment we say CM, we are assuming something.
I'm just.
Second time I have not mentioned.
No, I'm not saying this, Malad. Not assuming, Malad, an ordinary person, an investigation is taking place, Malad, and somebody finds that an offence under the IPC has been committed by an ordinary person. 66(2) will apply. 66(2) will apply.
Yes, you argue.
That's the point I'm making, Malad.
Yes, please.
Forget about authorities. At the moment, I'm saying 66(2) provides provides a provision under the PMLA that if number 1 applies, that is subsection 1 applies, and during the course of investigation, right, an offence is committed, then it must go to the state agency. Now there is a case, Malad, which has come to this court in respect of a Deputy Chief Minister of Karnataka, where during the course of a tax rate, Malad, it was found that certain other offences had been committed. Right, Malad? That was referred to the state agency. That was referred to the state agency. That was objected to.
Yes.
I think my lord is also aware of that.
No, we are not aware.
My lord is aware. My lord is aware because he
The questions are on a far larger scope in this petition. Because arguing 662 all right, but the questions here involved are on far larger.
I am not disputing that at all.
The allegations are true, then it directly strikes as a rule of law.
No.
It is Article 14.
That is the article.
1 second. Yes, we'll come to
This
that.
is what.
Well, at the moment, what was I interpreting? 66(2). I was not talking about this. I was interpreting. My lord said 62 doesn't apply.
These questions are important. You may be right.
Yeah.
Then the questions.
That's right. I'll answer that, Mullah.
Here, very large.
I'll answer that. Mullah, at the moment, I was only answering one small question. Your lordship said 66(2) doesn't apply. Your lordship said it doesn't. I was only answering that, Mullah. I was only answering that question. That 66(2) apply. Your lordships put to me another question altogether. You are saying even if 66(2) were to apply, this has a much larger ramification. It's what my lord is putting to me. I understand that.
By very nature of the controversy raised in the 32 petition, it is a very higher petition.
I agree, Manoj. I am not disputing that. I was at the moment, Manoj.
Very aspect to be seen in that.
That's correct. I will answer that, Manoj. I will answer that. I was just answering.
And why 66 may not apply is, we are asking the question. Sure. Not that we are assuming something.
Yes, sir.
If you don't ask any question,
no, please do.
Keep quiet.
Yes, no, Manoj. How?
And then deliver a judgment.
When I answer, Manoj.
Then you will.
Difficult.
Anybody.
True.
It's difficult.
Please ask.
What we have understood that, you see, there are two distinct allegations.
Right.
PMLA allegations at the first place,
right,
which ED is inquiring.
Right.
That is one set of allegations and one set of offences.
Correct.
And this particular allegation is a separate set of offences.
Right.
This offense, the second set, which the petitioners herein are alleging, that has not been committed in continuation of or while the investigation of PMLA offense was undergoing.
Yes.
There are two distinct offences.
Right.
While PMLA offense is going on, PMLA officers have not unearthed or come across some other offense. The present is an offense in which is committed by some other persons against PMLA investigators.
Your lordship is right.
Therefore, it would not apply.
Yes, what your lordship is saying is that here the offences have been committed against those who were investigated. That's what my lord is saying. Right, Malas? We'll accept that prima facie to be correct, Malas. We will accept that. Now, Malas, let's
why
see.
should you accept? When we say
No, prima facie. Since your lordship,
we say it is facts, you object to it.
No, I'm not.
And now you are
Malas,
accepting that.
I'm taking the argument forward. Malas.
Anyway, please proceed.
Malas, if you ask me question, I don't take the argument forward, the same thing will happen.
Exactly applies to us.
The same thing will happen, Malas, if you don't ask the question. Now,
And we ask the question, don't
see the offences.
Don't think that we are agitated.
Kindly see, Malas. Kindly see.
And don't agitate us by saying that we are agitated.
I'm not agitating you.
No.
Kindly see section page 38.
Yes. Page
38.
Yes.
Abetment, criminal conspiracy, voluntarily causing hurt, wrongful restraint, wrongful confinement, force, criminal force, assault on or criminal force, obstructing public servant in discharge of public functions, omission to assist public servant when bound by law, disobedience to order during promulgated theft, theft in dwelling house, theft after preparation, robbery, dacoity, criminal trespass, house trespass, destruction, all that. These are the offences that are alleged to be committed by the officers of the state. That's the allegation, Malas. Right?
Yes.
Now, Malas, these offences have been committed. I'll assume, for the sake of argument, I'll assume. What is the fundamental right to move? If a person has been kidnapped, Malas, let's assume person is kidnapped. While he is kidnapped, he can move under 32. But if he has been released, he can't move under 32. In the light of what my lord put to me.
No, I was putting it in the context of 66, not in the context of 32.
66, Malas, even 66. These offences cannot be investigated by an authority outside the police station where they were investigated, as the code itself and the BNS. Any offence committed, Malas, within the situs of a particular area has under the law to be investigated by the police officer. That is Malas, settled law. It can't be investigated outside. It can be investigated outside only pursuant to a 226 petition. Or a transfer petition. What my lord was saying to me is absolutely right, that there's a larger issue. There's no doubt about it. But what I'm saying is entirely different for us. The law cannot change because there's a larger issue.
Yes, according to Article 32 would not apply merely because there is a larger issue. Article 32 petition is not maintainable merely because there is a larger issue. That is your submission.
I'm saying, Malas, 32 petition is otherwise not maintainable. I'm not on the facts at all, Malas. I have indicated to your lordships how 32 is otherwise not maintainable. But 32 is also not maintainable on the simple ground that this offence, whatever it may be against A, B or C, will only be investigated in the area in which it has been committed by the officer in charge of a police station. That is under the BNS and under the old code, Malas. That can't be per se in law investigated by third parties. That can be done through a court. The reason why I put forward this proposition is, if there is a statutory remedy, that statutory remedy has to be followed. That was the proposition. Yes. I'm not saying 32 can't, it is on the maintainability of 32. I'm not on the facts. It is a statutory remedy. That statutory remedy has to be followed. You can't invoke 32. 32 article can't be invoked, Malas. And that's...
Yes.
Right. So, Malas, the point I'm making is, I am not, Malas, at the moment I'm on the fundamental point, it's not maintainable. So the proposition is not on the allegations. Proposition is there is a statutory remedy provided.
Offense.
These are offenses.
We investigated 66.
These are these offenses. BNS offenses. BNS offenses, brother. These are offenses under BNS, I hope, brother. These are not offenses under any other statute. These are BNS offenses committed in West Bengal, in Calcutta. Now, as your lordship knows, BNS says offenses will only be investigated by that police station.
Now, the tenor of your argument is to be the offense or the whole situation?
No, I'm not on situation, I'm on the offenses. My argument is 32 doesn't, I hope I'm making, I am saying 32 doesn't lie. I'm not saying anything else.
All is without thinking.
Yes.
It's all
I know, I am.
Without thinking.
32 doesn't lie is what I'm saying. If there is a statutory remedy available for a particular offense, 32 doesn't lie. That's all I'm saying. Right? Where does 226
that is fundamental principle.
Yes. And where does 32
whether it is
226
whether it is 226 or 32,
yeah.
If there is a statutory alternative remedy available, these proceedings would not lie. That is the fundamental.
No, I'm not even where the offense is committed, that police station has the jurisdiction to investigate that offense. Right, Malas? That offense can't per se be investigated by somebody else till there is a remedy, and that remedy is 226 by the person who is aggrieved. 226. And he can then allege that this can't be investigated here, as my lord put to me.
So you are saying that for statutory violation, 32 will not die unless it is a fundamental right.
Unless it's a fundamental.
That is what you are saying.
If it's a fundamental right, Malas, if it's a fundamental right,
then only 32.
No, Malas, I don't think that.
No,
I'm not saying that, Malas. Once there is a statutory remedy in respect of a criminal offense, Malas, I don't think I can make it clearer. There's a criminal offense committed within a particular area in a particular state. Then under the BNS, that investigation must be done in that state. Even if there's a violation of a fundamental right, it has to be done in that state, Malas.
Yes.
It has to be done in that state, even if there's a violation of a fundamental right.
Yes.
And there are remedies available. You can file a 226, Malas. But Malas, we are going beyond what I'm arguing. I'm not arguing that.
This principle applies to 226 also.
Yes.
That if a statutory remedy is available, then 226 is not.
But in this case, the statutory remedy is the commission of an offense and an investigation.
Yes, we have understood.
That's all I'm saying.
We have understood.
Right. And 226 will lie where you say it is not being investigated. If it is being investigated, 226 will not lie.
No, we throw petitions. 226 petition on this ground also that go 156.3, invoke 156.3. Don't ask for a mandamus or registration of a FIR.
Right.
Sakiri Vasu.
Right.
Yes.
No, I understand that, Maras, but I am not arguing that point at this point. I am only saying that at this stage, that fundamental right cannot be invoked unless there is an investigation and that investigation is not moving forward properly. Then only it will be invoked. You can't assume. Cannot assume facts. Maras, for example, Maras, can they say that the state police cannot investigate that offense, Maras?
Yes.
As far as our allegation is concerned, with the commission of offences by them. Therefore, I can also file a 32. Is that the case, Malas? The NCP, ECR.
Essays are always interesting.
This one in particular.
No, whichever case.
Kindly see.
Yes.
Let's kindly see third paragraph, third page.
Yes.
So well done. Article 32, this is NCPCR, Mullahs, moving the court under 32.
Is a vital provision, yes.
Yes. Article 32 is a vital provision of Part 3 of the Constitution, which deals with fundamental rights and is a fundamental right by itself. This court can issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari right, whichever may be appropriate for the enforcement of any right referred by Part 3. Citizens are entitled to appropriate relief under the provisions of 32, whenever there is a violation of any fundamental right. No doubt, when there is a violation of the fundamental right, public interest litigation is also preferred by and on behalf of citizens by public spirited persons, which are also termed as social action litigation. However, we find it strange that a statutory body, such as the petitioner in the instant case, is invoking Article 32 of the Constitution for seeking the aforesaid relief. When Article 32 is meant for citizens to enforce their fundamental rights, the said article cannot be the basis to file a writ petition by statutory authorities against the state, union, territory for seeking directions in aid of discharging its functions under the statute. The said article also cannot be the basis for statutory bodies or authorities to seek enforcement of fundamental rights against private citizens. The same is incongruous and not in accordance with what is envisaged under the Constitution. Direct authority on the point. Even if it's a statutory authority. And in this case, Maharaj, that's not the case at all, according to us, as I have argued and Mr. Devan has argued. The Directorate of Estates is not a statutory authority. Now Maharaj, kindly come.
But please concentrate on the fundamental right of the officers of the ED with whom or by whom the offence has been committed.
On that, I have made my...
Otherwise, you will miss the point, both.
You are right.
If you only concentrate on ED, and forget the second petition,
correct,
which is preferred by the individual officers,
right,
who are the victim of that offence.
That is Robin.
You will be in difficulty, I am telling you.
That's what I am not arguing.
If you argue ED, and don't argue the individuals who are the petitioners in the other petition,
right,
then probably you may miss the point. That is what we are alerting you.
Argued by someone else, I am not arguing.
Whosoever is arguing, we are telling you. Yes.
What is it?
Now, whosoever is arguing, otherwise.
But in the first petition also, petitioner number 2 is the deputy director.
He was not there on the spot.
Personally.
That is what Mr. Sibbal has said.
He is an accused in the FIR registered by them. I show that.
He is an accused.
Yes.
No. Then he is a better case because if he is not there according to Mr. Sibbal.
Both the petition.
While he is sitting in Delhi and he is made an accused for something.
Accused in what?
What? Everyone involved in the rape.
In our case, which has been stayed, that's all right, Mullah. It's not in their case.
Lord, he was in Calcutta. He was the supervising officer. He was supervising this search. I'll come to that.
On the spot. He was not on the spot. He doesn't have a fundamental right. Nobody interfered in his activity.
What Mr. Sibbal said that P2 Robin Bansal was not at the scene of occurrence.
Yes, he's not there.
He says that I am filing this for the officers of
CBI,
including myself.
I have already told that to the court. You can't be filing a fundamental right petition for others.
Yes.
Basic principle. What have they said? Which person has been? But she will answer that because she is in that petition.
Yes, because
I'm not in that. What the allegation was? She will answer because I'm not. She will take care of that. But let's kindly come now to now, Malaz, as your lordship said, I told your lordships last time, obstruction of a public servant is an offence under 221 of the BNS. Right, Malaz?
Yes.
So they have a remedy?
Yes.
And that's their right, statutory right at best, Mullas. Because it's not a fundamental right. The point I'm making, Mullas, none of these are fundamental rights. A person performing a statutory duty, the violation, any obstruction in the performance of that duty is not a violation of a fundamental right. Mullas, for example, a police officer is discharging his function. Somebody obstructs him. He can't file a 32 petition. He also can't file a 226 petition. There will be a prosecution launched for us for violating his right to discharge his functions. So where is the question of 226 or 32 coming? Because there is a statutory remedy. Now, you can't say, no, we don't have to go through that statutory remedy. I can file a 32. Well, then every police officer will have a file a 32. A state police officer will file a 32 against them. Then what will happen? So you can't interpret a law in the context of a particular fact situation and then open a Pandora's box which will be inconsistent with the basic features of the Constitution as well as the basic features of criminal law. So ultimately it boils down to this. A person performing his statutory duties, if he is interrupted in the performance of those duties, then per se there is a violation of a fundamental right.
Yes.
That's the proposition probably by the other side. That's a proposition which, with the greatest respect, cannot be accepted because a person has no fundamental right to investigate. He has only a fundamental right. He has only a right under a statute to investigate. And a violation of that right is not a violation of his fundamental right.
Yes.
Right. Now kindly see his averments in ground ZZ, mothers. Page 41.
Page?
41. Because false, frivolous and retaliatory FIRs were deliberately registered against ED officers not on account of any unlawful conduct, but solely with the object of criminally intimidating them, browbeating the investigating agency and deterring the performance of statutory functions under PMLA, which is the teeth of Article 14 as well as Article 21. Where does Article 14 or 21 come in here, Maras? If the allegation is that they have committed offences, Maras, how does Article 14 and 21 come in? Guarantees free and fair investigation by investigating agencies. How does that 21 come in? Then let's kindly see grounds AA at page 27.
Page 27.
27. Ground AA. Because the search and seizure operations conducted by officers of the Enforcement Directorate were lawfully authorized under 17, pursuant to reasons to believe. Right, Malas? So therefore, they are exercising their statutory rights. Now kindly come to DD, page 28. Because the acts of wrongful restraint and confinement of ED officers, possible removal of digital devices, disruption and intimidation during search collectively amount to frustration of statutory powers. They are not talking of fundamental rights. It is their own case, Malas, that they were exercising their statutory powers which are frustrated. Which is that fundamental right that is violated? That's why 221 of BNS. Then when was GG at the bottom of 28, because section 67 of PMLA, protection of action taken in good faith, provides that no suit, prosecution or other legal proceedings shall lie against any officer for anything done or intended to be done in good faith. Because the ED officers were acting strictly in discharge of statutory duties. There it is. Then page 43. It is their own case, Malas. triple L, at page 43.
Yes.
For that, the facts disclose direct involvement of highest political executive, abuse of police power, theft and manipulation. That this honorable court has consistently held that where high and mighty states are involved in commission of cognizable offences, investigation ought to be transferred to CBI. This is now, they are going beyond the fundamental rights issue. So, the petition, the argument before your lordships is, it is their own case that in the discharge of their statutory duties, certain offences under the BNS were committed. That is not the basis of a fundamental right, can't be that. And the PMLA itself demonstrates that powers flow from the statute, not any provision of the Constitution. Powers don't flow from 21, don't flow from 14, don't flow from 19. They flow from the statute itself, whether it's the CBI or it's NDPS or any other statute. They flow from the statute. A violation of the statutory exercise of power is not a violation of a fundamental right. As a matter of law, it can't be. Now, I read to your lordships the other day and I don't want to repeat it, Just to show 49, your lordships will remember, 48 and 49 of PMLA.
Yeah.
So that we are clear on what the submission.
48 and 49.
48 and 49.
Yes.
49 says, the central government may appoint such officers as it thinks fit to be authorities for the purposes of this Act. Right, and there shall be the following classes of authorities. So the authorities are appointed by the central government. That goes to the first proposition that I addressed your lordships on.
Yes, yes.
Having been appointed by the central government, the Directorate of Estates can't have a fundamental right. The aggrieved party is the central government. And the central government can't file a 32 petition, as I mentioned to your lordships. Nor can the central government file a 226. The individual certainly can file whatever he wants to file, but that individual can only go under BNS 221 because he is being obstructed. He has no fundamental right. And he is claiming it as an officer of the ED, not in any other capacity. I can understand if he claimed it as an individual, but not in any other capacity. Because he is saying, even in the other petition, it's the same. He is only claiming it as an officer of ED. So where is the question of a fundamental right here? Because the moment your lordships were to even lay down that law, then every officer in discharge of his, whether it may be customs, it may be any officer, the moment he is obstructed, it is a violation of his fundamental right. That, with respect, would not be a proper enunciation of the law. Then, now let's kindly see, very interesting here. But before I go to that, a more fundamental issue. When is a fundamental right, when can a fundamental right be invoked? Basic principles. When it is being violated. A fundamental right cannot be invoked when the alleged offense is already committed. As a matter of law.
Yes.
Well, I am forcibly kidnapped by somebody. My wife goes to court and says, look, I want to file a petition. My husband has been kidnapped by somebody. It's fundamental, and he continues to be kidnapped. Petition will lie. But if he is kidnapped and he is released, and then she invokes Article 226 or 32, petition won't lie. In Sonam Wangchu, for example, he was released. It was dismissed as infructuous. Why? Because the fundamental right doesn't inure to his benefit anymore. So all these allegations are made with what happened in the past. So how do you invoke a fundamental right in respect of incidents that have taken place? You can only invoke your powers that, look, an offense has been committed, and therefore proceed in the matter under 221. There is no existing fundamental right today at the time when the petition is filed. This is a fundamental issue, that your lordships will have to decide.
For that only we are hearing.
No, I'm making the propositions.
Yes, yes.
Fundamental issue where the propositions that I'm addressing your lordships on.
Yes.
It has to be an existing fundamental.
Yes, yes. It could be a continuing violation of a fundamental.
That's right. Then only it will be invoked.
So that we invoke or issue the writ.
Exactly.
Continue.
My lords, may I mention item 16? Interim order may be extended.
Item
16. Interim order.
16.
Sorry, Millers. Item 25 is the Delhi matter Millers edition. So cost of 51 hospitals Millers was returnable today. May not be taken up possibly today. Millers may give another date Millers.
We'll see at the end of.
Very well.